Hello and good evening to all of you. I hope you all are doing good. Yes. So, what is the topic for today's discussion? Have you all referred to the topic before entering the class? And if you have referred to the topic, you will understand that this is very, very relevant for your examination because this talks about one of the very important law, that is CPC, right? So the procedural law that relates to the civil aspects, wherein we are specifically talking about Order 39. And which rule of Order 39? We will be specifically covering Rule 2A. So if you are aware, if you have studied about CPC in your college days, write in the comment section as to what is Order 39 all about. CPC 1908, Order 39. What is this about? Yes. Yes. So as you have answered, this is related to injunction, right? And which sort of injunction? Where else is injunction present? You should be knowing this. This is relevant for your exam. You are expecting RJS. You are expecting the mains exam for Himachal. So all of these exams, if you're preparing for it, if you're an aspirant for it, you should be knowing these basic elements, right? Now let's try to understand what are we basically talking about in this relevant judgment, very recent judgment. All these recent cases that keep coming, all these updates that keep coming every day, we put it on LiveLaw as well, right? So if you have the LiveLaw app, you can read all the updates on everyday basis, which will help you grow on the concept that you have already studied. So even though if you have studied about temporary injunction, what will be the procedure for contempt if in a situation you have gone against the order of the court? What will be the way through it? Whether you can be sued for the same? What is the remedy? What is the punishment? The term that I'm using here is punishment, right? So क्या आपको पता है punishment और remedy में क्या difference है? ये key points हैं जो आपको clarity होनी चाहिए for you to become a judicial officer, right? Okay, so let's begin. I will show you the law relevant provision, then I will tell you the story, and then I will tell you what has been held in the case, and then I will show you the judgment or the copy of the judgment. Okay, अगर आपको copy of judgment नहीं देखनी है तो आप story तक सब समझ सकते हैं, concept समझ सकते हैं, and you can just add a sticky note to your notes where you have already made notes of Order 39. You can add a relevant point, put an asterisk mark, and write this as an addition. Okay, if you want to understand interpretation, if you want to understand what has been the rationality, if you have to understand what have been the issues, how the issues were framed here, ye jo procedurally aapko pata hona chahiye, all of this also you can do if you continue to listen to the class. Okay, so let's go to Order 39. I will not be getting into the nitty-gritties of Order 39 Rule 1 and 2 per se, because वो एक अलग से topic है. If you want us to cover it, we'll be more than happy to do that. Okay, so what is this basically about? Here, as you understand from the title itself, this is related to temporary injunction, right? And this temporary injunction will be granted to you when you apply by way of a suit, right? So in any suit, you will have to prove certain factors, and accordingly, the order of injunction can be granted. So the court may order to grant a temporary injunction. And likewise, if it continues accordingly to Rule 2 also, the court can order or can apply for a temporary injunction to restrain the defendant from committing breach of contract or any other injury. So a temporary injunction, if I have to simplify, let's say if you are a first year student, you have to understand. So injunction is to stop, right? Injunct, that is to stop. So if in a situation, let's say X has filed a suit against Y, और ये जो मैं hypothetical facts बता रही हूँ, this is relevant to the case that we are discussing here. If you want me to show you the name of the case first, so this is the name of the case right here. I'll just highlight it in pink for you. Yeah, you can see the name of the case. Okay, you have the citation also. We provide you, LiveLaw also provides you citation, so that is also available here, right? Okay. So what have been the facts of this case? Let's try to understand that. Let's say in a situation, X and Y have entered into a contract. Okay. This was a joint development agreement, and in this situation there were promises made that the construction will be done by a particular stipulated date. Now if you have studied contract, you understand that time can also be an essence of the contract depending on the terms of your contract, correct? Now here the party has defied to fulfill the promise that they have made. Okay, so let's say this Y is defendant and X is our plaintiff. In this situation, where Y does not fulfill the promise, X goes to the court and says that I want to get this contract to be declared as that the person has not fulfilled the duty. Okay, so he is reaching to the court for declaration. Now, how many of you have studied Specific Relief Act? Yes. If you have studied, you have to tell me the provision for declaration. How can you apply for declaration in a civil case? Okay, let me know in the comment section, and we will be addressing all your doubts also by the end. So if you have any doubts, you can write it in the comment section. By the time I address the entire facts and the outcome of the case, I'll then take up your questions. Okay. So what has happened here? The X has applied for declaration while the suit is pending. There are a lot of other facts also of the case, but I'll not be getting into the details of it. Whatever is relevant for your exam, for you to understand this concept, I'll be covering that. Okay. So while this case is still in pendency, this is the important factor. Okay. The case is still in pendency. There is no decree that has been given. These two are different stages. And if a party does contempt of the court order, then the remedy are provided in different provisions. Okay, so that is why I have highlighted this for you. If the decree has been given and the other party does not actually help the court in execution, defies the execution of the decree, then we already have provision under Order 20. But we are not going at that stage. Rather, we are at the first stage, wherein we see that there is pendency of the case. And during this pendency, this Y, okay, the person who is a defendant here, the representative of Y writes an undertaking and provides an undertaking to the court. And the undertaking is about promises. Y promises to the court that I will not transfer this property. Okay, so during the pendency, till you decide the case, I will not be transferring this property to anyone. Now, this is an undertaking given by the advocate of Y on behalf of Y, representing that Y has made this commitment that he will not be making any transfer, right? And accordingly, after this, the court also passes an order and says that do not transfer any property. Now, this is an order given by the court, right? And are we supposed to follow the orders given by the court? Yes. What is the reasoning of the same? We will get into the discussion of that. Okay. What is the role of this advocate? If ma'am ने advocate पे इतना emphasis किया है, so there must be some relevance, right? So why are we talking about the advocate, and why are we saying that this order has been given by the court? It's not only the undertaking or the promise made by the defendant, but also the order given by the court, right? So the court has said that do not transfer the property when the suit is still in pendency. And why does not really follows this? Okay, why did not follow, and why made subsequent transfer on two different occasions. Subsequent transfer. Abhi aap story suniye and you will get to know that what is the catch here. Now, what really happens in this case is, did X win the case? No. X did not win the case. Okay, so for the suit related to declaration that he had filed, he did not really win the case at the end, and the court says that with all the evidences that you have provided, we do not see that defendant had actually done breach of contract. Okay, now in such a situation, what will happen to this order of the court? Will the contempt, or can the contempt proceeding still be initiated? Or the contempt proceeding will also not be initiated because the suit also has been dismissed by the court in such a situation. Did you get the catch? So the question here is, because the catch here is because the judgment was not given in favor of X, right? X was not able to prove to the court that Y had done breach of contract. And in that situation, if in between this order given by the court, if in between this the party has defied the order of the court related to not transferring the property, can the contempt proceedings be initiated against the party or not, against the defendant or not? So this is the factors. These are the basic important facts that you have to remember about the case. Now I will take you to the relevant provision. Let's read the provision and then we try to apply it. Okay, so whenever you get any fact, you have to know that what are the relevant provisions related to it. So very specifically, we have Order 39, Rule 2A. Okay, what does it talk about? It says consequence of disobedience or breach of injunction. So if in a situation you have done disobedience or breach of injunction granted by the court, ordered by the court, in that situation, what will be the consequence? So the title per se does not use the term penalty, right? Does not use the term remedy. So these are catchphrases that you must remember. These are catchphrases that will give you clarity. आपके एग्जाम में एकदम डायरेक्ट क्वेश्चन आएगा कि ऑर्डर 39 रूल 2A का टाइटल क्या है. So आपको पता होना चाहिए. It does not use any other term, but it uses the term consequence of disobedience, which you do not really see in a lot of provisions, right? So इसीलिए ये important है, different है और important हो जाता है. Okay, now what does it talk about? Let's try to read one by one. What is the type of remedy? Okay, as you are going to be civil judges, you should know what is the power, what is the nature of remedy that is actually mentioned under this provision. So let's try to read that. In the case of disobedience of any injunction granted or other order made under Rule 1 or Rule 2, which talks about the temporary injunction granted by the court, or breach of any terms on which the injunction was granted or the order made, the court granting the injunction or making the order may order the property of the person guilty to such disobedience or breach to be attached. So first is that your property can be attached. Okay, if you have defied the order of the court, here in our given situation also, which we see has happened, in that case, your property can be attached. Secondly, it may also order such person to be detained in civil prison for a term not exceeding 3 months. So there is imprisonment also, but it is the detention in the civil prison, and the time period also is important for your preliminary exam, which is 3 months. So order Rule 2A, wherein we have 3 months of period, unless in the meantime the court directs his release. Okay, so these are the essential factors which are important for you to remember when you associate and when you try to understand the reasoning of the case. Now, अब इस केस में हाई कोर्ट ने इसी प्रोविजन को माइंड में रखते हुए कोर्ट ने सारे फैक्ट्स को पढ़ा, कोर्ट ने सारे फैक्ट्स को समझा और कोर्ट ने एक्नॉलेज किया कि यहाँ पर एक डिक्री नहीं आई थी. सो मुझे ऑर्डर 21 की हेल्प लेने की जरूरत नहीं है. मेरे पास ऑर्डर 39 रूल 2A है जो एक प्रोटेक्शन प्रोवाइड करता है टू जुडिशियल सिस्टम. ओके, नाउ दिस इज नॉट अ प्रोटेक्शन. अगेन मैंने आपको बोला था मैं आपको जजमेंट पढ़ाऊंगी, उससे पहले मैं आपको सारे रेलेवेंट पॉइंट्स बता रही हूँ. सो ऑल दीज पॉइंट्स आर फ्रॉम द जजमेंट इटसेल्फ. ओके, सो कोर्ट ने हाईलाइट करके बोला है दैट judiciary co-protection, judicial system, as we associate, we give respect to the system. It is not only for a specific judge, it is not only for an individual judge, it is rather for the entire system, wherein you have to ensure that people respect it. Okay, so continuance of respect will happen when you have these provisions. Okay, when you allow and when you acknowledge that the court will have power to initiate contempt proceeding against the violation of its order, right? So accordingly, the court has first referred that we have this window under 2A which we want to impose, which we want to invoke right now, and the court accordingly have imposed compensation to be granted, has also said that there will be civil imprisonment against one of the defendants. Okay, and the court has also acknowledged that there will be attachment of property. ये सब कुछ हुआ हाई कोर्ट की स्टेज पे. ओके, सो सबसे पहले क्या हुआ, सिविल कोर्ट ने आपके केस को, आपकी डिक्लेरेशन आपको नहीं ग्रांट किया. अगर आपको डिक्लेरेशन नहीं ग्रांट किया, अब मैं आपको टेक्निकल पार्ट बता रही हूं, तो क्या आप एक अपील डाल सकते हैं, रेगुलर फर्स्ट अपील? यस. सो आप इस सिविल सूट से एक रेगुलर फर्स्ट अपील डालेंगे फॉर द डिक्लेरेशन टू बी अगेन checked, right? So to seek that I am appealing that the declaration was not granted, and you reach to a higher court by way of RFA. right? Regular first appeal. At the same time, you also have this window and which has been invoked and initiated by X, wherein he is saying that the contempt proceeding should be initiated against the defendant because of the violation of the order of the court. Okay, so these are two aspects of how the proceedings are running in this given case. And in addition to that, we also have understood that what the High Court has said. Now, this is challenged by the defendant because High Court ने defendant के against एक order दिया है, तो अब वो challenge कर रहा है उसको in the Supreme Court, and the Supreme Court has to assess certain question. Now, I am telling you the issues that have been addressed in the judgment that I have shown you. Because this is a judgment given by the Supreme Court, so we are addressing, and now we are going to get into the information and aspects of what are the issues here. So the first issue is with regards to the power that is granted under Rule 2A of Order 13. Okay, so क्या consequence of disobedience, ये जो order था, contempt का जो order था, क्या ये invalid हो जाता है, क्या ये अपने आप ही extinguish हो जाता है when the plaintiff doesn't get an order in his favor, या ये continue होता है, या ये एक separate remedy है और ये दोनों अलग हैं. So plaintiff का suit, whatever has been held here is different from this aspect, right? So ये पहला question है जो court address कर रहा है. The other question that we have over here is with regards to the idea of disobedience of court. Okay, so when we want to acknowledge that why disobedience has to be seen, how it has to be seen, why the power has to be invoked, so we also have to give reasoning. In this case, the reasoning has to be given by the court. So वो एक second aspect होगा, and the third and very important aspect is जो अभी हमने ज्यादा नहीं पढ़ा है but अब मैं आपको बता रही हूँ, is related to the advocate. Okay, so here this judgment also talks about the advocate and the client relationship. So आपके एग्जाम में ऐसा हो सकता है कि आप एक शॉर्ट नोट पूछा जा सके आपसे, क्योंकि एक नई जजमेंट है, इसने इस एस्पेक्ट को कवर किया है, ऑन द रिलेशनशिप बिटवीन एडवोकेट एंड द क्लाइंट. ओके, व्हाट आर द ड्यूटीज? अभी बहुत रिसेंटली हमने देखा कि एडवोकेट्स एक्ट में चेंजेस इंट्रोड्यूस करने गए थे. अभी हमने देखा दैट वी हैड जजमेंट्स आल्सो गिवन इन द प्रीवियस ईयर कंसिडरिंग वेदर एडवोकेट्स शुड बी फॉलिंग अंडर द कंज्यूमर प्रोटेक्शन एक्ट. ये सब रिसेंटली हुआ है. दैट इज व्हाई this is something related to that. This is something which will be an addition to that, and you should be knowing about it. And also as a lawyer, as a law aspirant, judiciary aspirant, all of this makes it important for you to know that what is actually the relationship or nature of relationship between an advocate and his client. Okay, so ये third leg है और discussion का जो कोर्ट ने address किया है, कोर्ट ने answer किया है by explaining that how it has to be seen. Okay, so कोर्ट ने यहाँ पे क्लियर किया है कि एक fiduciary relationship exist करती है. There are some certain precedents that the court has taken help of. जैसे आप देख सकते हैं from the beginning of the judgment itself, there are judgments. The court has highlighted that we have relied on this 1998 judgment. Very, very, very relevant for you to understand the nature of this particular provision. Okay, then the court says that to talk about injunction and what is the nature, what is the remedy, they again have referred to a precedent. And again, with regards to advocates, they have referred to certain precedents in the judgment, wherein they have said what? Now I am summarizing this already for you, then I will show you this from the judgment. Advocate-client relationship, when we started seeing it, we understood that advocate were, they were the spokesperson for, and I'm going back in the primitive times, in the traditional times, that advocacy was introduced as one of the profession because people started acting as spokesperson for the others who could not represent, others who were not aware of their rights. So this is the background with which we started this profession. Then it was acknowledged as one of the ways of livelihood. People started associating that this is my profession, I'm earning my livelihood out of it, and accordingly the nature of the job also changed. And the court time and again has been reiterating on the point that there are certain set of duties that the advocate has, right? These obligations are not only towards the client, this is also towards the court, this is also towards the opposite party, this is also towards the society at large, right? So ye एक एडवोकेट की बहुत सारी ड्यूटीज हैं। स्पेसिफिकली इस केस में क्योंकि क्लाइंट बोलता है, डिफेंडेंट बोलता है, मेरे एडवोकेट ने अंडरटेकिंग दी थी मुझसे बिना पूछे, मेरे असर्शन के बिना, मेरी सहमति के बिना, मेरी परमिशन के बिना, मेरी कंसेंट के बिना। एज आई टोल्ड यू, वेरी इंपॉर्टेंट पॉइंट दैट आई हैव हाइलाइटेड हियर इन द डायग्राम दैट आई हैड मेड, राइट। सो ये वही पॉइंट है कि अंडरटेकिंग तो किसने सबमिट की थी, लॉयर ने, बट कोर्ट ने बोला अगर हम फैक्ट्स को पढ़ते हैं तो हमें समझ आता है कि अंडरटेकिंग जब फाइल हुई उसके बाद कई बार हमने अपने इंजंक्शन के ऑर्डर को एक्सटेंड किया एंड द पार्टी वाज प्रेजेंट। एट द सेम टाइम हमने जब अपना ऑर्डर इशू किया दैट यू विल नॉट बी ट्रांसफरिंग दिस प्रॉपर्टी ड्यूरिंग द पेंडेंसी ऑफ द सूट, आपको वो भी अवेयरनेस थी। So in all these 4 years, you did not say anything. You could have changed the lawyer, you could have shown some concern, but you did not do anything. So that shows that you actually, you were associating and you have given consent for this thing as well. Okay. So ये question relevant हुआ in the judgment because the defendant highlighted that I had not given the permission to my advocate in this given situation. The second aspect is the court tries to go into precedent and the court says, how do we see advocate-client relationships now? So we see them now that the advocate acts as an agent of the client. Okay, he is supposed to, yes, definitely he is more aware. You are going to the advocate to get remedies from him, to get feedback, to understand what is the best possible remedy. But the advocate is supposed to tell you that these are 4-5 avenues available and wherein we can go and seek remedy. Now it is on the client to make a final call. Okay, so client के पास ही final call है, client के call को supersede करके advocate कुछ डिसाइड नहीं करेगा. And this is how the court has tried to explain that how do we see advocate-client relationship at present. So even though when we say that, the advocate acts as an agent, but it acts as an agent to a certain limit, and that limit has to be decided by the client itself. So the decision making power lies with the client. The advocate is the agent or is going to make the representation. And then coming to the specific facts, the court has clarified that यहाँ हम बहुत clearly समझ रहे हैं that the client had given implied authority, implied consent, ratification later, because he never said anything for those 4 years when all of this was already disclosed to him, when he was aware about the undertaking, the promise that they have made to the court for not transferring the property. Okay, फिर क्या हुआ इस केस में? अल्टीमेटली सुप्रीम कोर्ट ने अल्टीमेटली बोला that yes, keeping in mind the power given to us under Rule 2A, we are going to allow first that contempt has been done, therefore attachment of property will be done. At the same time, if you see, the provision says आप attachment करेंगी property की, अगर ये continue होता है breaking of the orders, defying the orders of the court, then in that situation the other party, the court can also do attachment plus sale of the property, and whatever money is there, money is received, can be paid as compensation to the aggrieved party. So इतनी wide extent की power है contempt की, right? और इसीलिए जजमेंट में बार बार प्रेसिडेंट्स को कोट करके क्लैरिफाई किया है जजेस ने अपने खुद से that this power has to be used sparingly. This power has to be used keeping in mind that contempt proceedings have to be initiated only and only when we see that the dignity of the court is at stake. Okay, that there has been violation of the orders of the court which is not justified, and therefore all of these stern decisions are required to be taken against the पार्ट. ओके, सो ये सारी समरी है. कोर्ट ने imprisonment हटा दिया, हाई कोर्ट ने जो imprisonment दिया था, because court acknowledged that the defendant is now of 68 years of age and it will not be fine to go ahead with the civil imprisonment. So the court says that I am increasing the amount of compensation. पहले 10 लाख था, अभी उसको 13 लाख कर दिया, और ऐसे ही accordingly remedy was granted in this case. So if you have understood the case, if you want to go and study something else, you think you are done with all the understanding of the case, you may leave now. You can drop your questions in your chat box. You can also leave your comments in the chat box. Tell us which judgment, relevant topic, any hot topic that you want us to cover. At the same time, if you really want to see how the judgment has been written, what are the issues, did ma'am miss on anything, you can now continue in the class and you can just go through the judgment with me. Okay, judgment reading thoda sa dry ho sakta hai when you have so much to do. I understand that you have so many subjects and different subjects, different tastes. Some may like civil law, some may like criminal law, and I understand that it looks like a burden, but this is important. As you see the competition is growing, you also see that a lot of questions are based, all your problem based questions come from these recent judgments. Secondly, if they are not being asked directly, even if I specifically ask you about the nature of the remedy given under Rule 2A of Order 39, that case also you have to mention the recent judgments there, right? So it is important for you to get accustomed. And आपको ही तो judgments लिखनी है बाद में, so you have to see at least the judgments, right, for you to write them in future. Okay, so now let's go and just scroll through the judgment and just get this will also be a summary for you of whatever we have discussed. So here, जब आप जजमेंट्स खोलते हैं आप हमेशा इंडेक्स को पढ़िए. ओके, इंडेक्स अलग अलग तरीके से हो सकते हैं, टेबल फॉर्मेट में हो सकता है, इस तरीके से हो सकता है. ये आपको एक आपके दिस विल हेल्प यू question yourself as to what do I know about this and how is this relevant for my exam. So as I told you, if you only read the bold part, okay, the judgment has not even started, if you only read the bold part of it, you will get an idea as to why is this important for your exam. Okay, so let's begin what all have been addressed here. So firstly, we stop here at the issues. The issues highlighted here by the court is that when the petitioners have made out a case of breach or willful disobedience by the respondents of the order passed by this court in pursuance. So basically this is talking about that whether contempt has been done or not, okay, when they have not followed the order of the court, and what order are we specifically speaking of. Okay, and then accordingly all the arguments made by both the parties have been addressed here. कौन से relevant provision है, order 39(2)A हम पढ़ चुके हैं, and हमारे पास section 151 CPC है. What is section 151 CPC? Yes, take a second and then let me know in the comment section. Yes, section 151 of CPC, very important. And can you tell me that what is the similar provision which talks about similar aspect of the power of the court which is present in BNSS or CRPC? आपने जो पढ़ा है आप वो बता सकते हैं. If you know 151 CPC, then the other question will be that what is the other relevant provision very similar to this, specifically talking about the power available to the criminal courts. Okay, so this is specific to CPC and therefore civil courts. Okay, चलिए आप आंसर करिए. And yes, so the judgment here first starts and talks about that how the previous judgment related to Sami Khan and Bindu Khan 1998 has clarified that the trial court, when there is pendency, they have the power to if their orders are not followed and violated, they have a power to initiate proceeding under Rule 2A. Okay, then we are speaking about the facts. इसमें dates mention की गई हैं because ये पूरा case है, तो actual में dates बहुत relevant हो जाती हैं कि आपने कब alienation किया है, right? So alienation of property should be done within or during the the pendency of the suit, क्योंकि temporary injunction grant हुआ है. So you must know, right, that temporary injunction जो है, the minute the final decree is passed, we understand that the temporary injunction gets merged with the final order, right? So accordingly, we also understand that यहाँ 2A कब invoke होगा, wherein we specifically see that the pendency is still there related to the suit. Okay, then these are certain arguments that have been made. Then they have highlighted the dates also, that the order was passed in 2011 and therefore the final dismissal of the suit against SEC, declaration नहीं allow किया, was done in 2013. So definitely meanwhile उसमें आपने किया है, so 2A की jurisdiction जो है वो invoke हो जाएगी. Then the court, other aspect is the court talks about balance of convenience. देखिए injunction एक अपने आप में बहुत important और relevant topic है, और जब आप उसको पढ़ेंगे आपको समझ आएगा that balance of convenience is very very important for the parties to address. Okay, so one party's right to take hold of the property, and the other party's right that is there for, for not transferring the property, not dispose, even though later the judgment come in his favor, meanwhile when it is still in pendency, he or she cannot transfer the property. Okay, so that is why balance of convenience has to be addressed. Then the court has made the distinction between order 21 and, speaking of, order 39 rule 2a. How are two different? Both, one is related to decree and the other one is related to the pendency. Okay, so sirf last wala part padhte. There is complete fallacy in the argument that the provision of order 39 rule 2a would also include the case of violation of breach of permanent injunction granted at the time of passing of decree. So decree pass hui hai, permanent injunction mila hai, to ye wala आपका ऑर्डर 39 रूल 2a नहीं लगेगा, इसको याद रखिएगा, ठीक है। फिर कोर्ट ने बोला है कि अगर लेट्स से एक्स सक्सीड कर जाता है इस गिवन सिचुएशन में, तो आपका रिगर, आपकी जो पनिशमेंट है 3 महीने मैक्सिमम है, तो शायद 1 महीने हो सकती है, कम हो सकती है, फाइन कॉम्पनसेशन कम हो सकता है, बट अटैचमेंट ऑफ प्रॉपर्टी शायद नहीं हो, राइट। मैंने फाइन बोला है बट कॉम्पनसेशन होगा, ठीक है। बट एट द सेम टाइम वी हैव टू अंडरस्टैंड दैट ये सब कुछ डिफर कर सकता है, बट फिर भी jurisdiction of 2a तो इन्वोक होगा ही होगा। ओके, देन स्पीकिंग अबाउट दिस पार्ट नाउ स्टार्ट्स एंड टॉक्स अबाउट द रिलेशनशिप बिटवीन advocates and the clients, and very clearly it has mentioned that there are certain authorities, there are certain duties that the advocate has, and these are fiduciary duties, and client की autonomy को हमेशा हमें respect करना है, ठीक है। implied authority है तो भी implied authority cannot be countermanded by the express direction. Okay, so implied authority आप मान के कुछ भी ऐसा नहीं करेंगे which goes against the idea of the express discussion done between the client and the advocate. Okay, so all of this is related to this. These all paragraphs talk about the aspect of client and advocate relationship, and then the last part is addressing and speaking about the order, the High Court, whatever the High Court had decided. Now the Supreme Court says that we are extending, we are removing, we are deleting the imprisonment, and we are increasing the compensation. The enhanced sum that has to be now given is 30 lakhs of rupees. Okay, so this is the judgment here that we have understood, that we have discussed. I hope this has been beneficial. I hope this has been important. This is relevant. I am sure you know that already. I do not have to reiterate that again. If I have to summarize certain key points for you very briefly, I will suggest you, first thing, that try to again keep a note of this judgment. Okay, in your notes that you have already prepared, put a sticky note at this judgment, and accordingly, keep revisiting it whenever you are revising your notes. In addition to this, try to remember that what all is there, what is the time period of imprisonment, what is the nature of remedy that is to be given, and accordingly remember the title of the provision, rule 2a, order 39, rule 1, rule 2. आज के दिन में with this judgment you at least cover all these important aspects of the case. Okay, so with this I am stopping now. I will see you again with another relevant case. I hope you have some feedbacks. I hope you have some attributes to tell us that what do you want us to cover in the next class. Do let us know, and I'll see you again with another case. Thank you so much, all of you.